Welcome to Talmudic Treasures. Today we're learning Ketubot page 44, which discusses in the event that a person is selling a piece of property, let's say a piece of land, and he writes one document on a particular date, and then, let's say a few months later, he writes for the exact same property to the same person, he's selling the same land, but again, written for a different date. The question is, how do we understand this when it comes to these two documents? Do we say that they're both valid? So typically we say the fact that there's a second document that's written, that somehow shows that there was maybe some flaw with the first one. In fact, the buyer perhaps is admitting to the fact that the first one is a forgery and therefore it's invalid, and that's the reason why a second document needed to be written. However, that does not always apply. We don't always say that once you wrote a second document, it's going to automatically invalidate the first. That's only in a situation where both of them are a document of sale or a document of gift to one person to the other. But let's say, for example, the first document that you wrote was a sale. I'm selling you this land. And then a few months later, I write a document that says I am giving you this land. So in that situation, we say the fact that you changed up the language, we say that the first document is still valid, and therefore when it comes to any form of a lien, that will still be connected to the original date. But we say that there is a reason why he wrote this second document. And it's based on an interesting concept called Dina de Bar Metzra, that if you sell land according to Jewish law, you can't just automatically sell it to another person. Rather, your neighbor, a person who already owns land, he would much rather, if he wants to purchase property, not to have to purchase a land far away. He'd rather have an adjacent land connected to his current property. And therefore, you really need to give that person the ability, based on fair market value, to be able to make this purchase. However, if you decide to give your land away, no one can have any claim and say, how come you didn't give me the first right to be able to buy this land? And therefore, maybe the reason why the second document was written as a gift is in order to be able to avoid this issue, this form of a loophole, if you will, so that he would be able to gift this to his friend in a way, even though he actually paid for it, but this way, no one is going to say, you should have sold it to me first and given me the first right to sell it. On the other way, if a person, let's say, first wrote it as a gift and then afterwards as a sale, so he may have also done this because when it comes to the laws of a lien, of let's say this land is later taken away, so if a person gives you a gift of property and all of a sudden for whatever reason there was a lien on it and it was taken away, according to Jewish law, that person does not have the right to go back to the person who gave you a gift, and it was nice that he gave you a gift, and ask for the money back. But if in fact it was an actual transaction and it was stipulated as such, then in fact that person would be obligated and responsible to pay you for it. So depending on how it was written, we find that these laws apply. Obviously, tort law, all these different forms of laws rather, that are directly connected to documents and sale or breach of contract are extremely complex, and this was just a brief synopsis found on this page of Talmud.